This brings me back to 1995 December. At that point of time, we had examinations twice a year. We were lucky enough to have twice a year, so we could then fail in one and then could go 6 months later for the examination. Well, I've been asked to speak on practice and procedure. So, I guess practice and procedure primarily is what we are doing on a day-to-day basis in Supreme Court. So if you look at the Supreme Court as such, we know in the Constitution, Chapter 4 primarily deals with the Supreme Court. Now, if somebody has to come to Supreme Court and ask an advocate as to how does a person approach the Supreme Court, what are the various jurisdictions to approach the Supreme Court. Obviously, you start by saying if your fundamental right is violated, we can move under Article 32. Number 2 is that cases are pending in 2 states, you move for a transfer. If you have violated the orders of the Supreme Court, it's a contempt. Then of course from the High Court, when you have to approach the Supreme Court, it's either under 132, 133, 134, or of course the bread and butter of any Supreme Court lawyer, which is 136. Then the reference under 143. Various appeals under different statutes, the Consumer Protection Act, now the Electricity Act, and the Companies Act, the various appeals which are announced. And of course the less traversed is the suit under 131, the references under the Income Tax Act, or these others. These are largely the jurisdiction of the court. Now, since all of you are practitioners who are not taking the examination, and I presume that most of you are persons who are going to take the examination, with that 4 years here, I don't have to really dwell on the jurisdiction aspects of the Supreme Court. For example, let's say Article 32 itself is a fundamental right. It's Kochuni way back in 58. Sentence of Sentinel of the PV V.G. Rao judgment. But as usual, when a person approaches the Supreme Court, the normal first question in any Supreme Court judge will ask you is, why are you coming to the Supreme Court? Why didn't you go to the High Court? So, or the alternate remedy that's available. The judgments which say that alternate remedy should generally be availed of before you hit the Supreme Court. The judgment is saying that no, it's not necessary just because alternate remedy is available or not. For the examination, please be abreast with the latest case law, extremely necessary. The latest being, I think, Justice Chandrachud's judgment in 2021, 22, Justice Chandrachud and Justice Indira Banerjee, that Maharashtra chess something like that. So that takes a alternate remedy, and then of course the next facet of 32 is being a public interest litigation. Again, we start by why a PIL? It's the voice of the voiceless for the marginalized society of the country. The court felt that we must relax the concept of locus standi and permit persons to espouse the cause of people who do not have the capacity to please the Supreme Court. And that's how one of the most PUC, etc., etc., etc. And of course, then we also have cases on the abuse of the PIL. Janata versus Justice Chaudhary, the latest being Tehseen Poonawala, and how PIL is being abused, and that judgment of Justice Dalgir Bhandari, when the appointment of the Advocate General for Uttarakhand was under challenge, where the Supreme Court laid down the parameters of what is to be seen and how PI should not be used. That is broadly 32, but as I said, please be abreast with the case laws, which is extremely necessary because the examiner would definitely like to know whether you have read the latest case laws or not, because the text is available in most of the books, but what is more to be appreciated is your knowledge of the latest case laws. And from there, if we come to the contempt, Article 129, Supreme Court is a court of record, having the power to punish for contempt of itself. The word itself being discussed in that Nadia judgment in Supreme Court, where the question arose as to whether if a contempt is committed of a lower court, of an officials of the lower court, will that be contempt of itself or not? Supreme Court held that yes, it is not only itself but include lower courts also. To some extent, and then is the question of limitation as to whether 124 and 215 are circumscribed by the 1 year limitation as given in the Contempt of Courts Act. One view just taken is that 129 and 215 being a superior power cannot be hedged by a limitation under the Contempt of Court Act, but a bench of 3 judges in Pallav State took a decision otherwise, and they said no, being primarily a criminal law, it is bound by the 1 year limitation. However, the limitation extended from the date of the knowledge. Then comes 132, 133, 134. 132 is of course when there is a certificate, when the High Court feels that it's a question of law for interpretation of the Constitution. 133 is for civil cases where there is a question of law of public importance, or if it is the opinion of the High Court that the matter must be considered by the Supreme Court. 134 is for criminal cases. And for 132, 133, 134, the certificate is given under 134A. The significance, of course, is that it's an appeal which you file. But again, all of us know that even though it's an appeal, but it still comes for scrutiny as a miscellaneous matter on a Monday, Friday, and treatment we all know is as it is given to normal one. But however, it's an appeal. And coupled with it is the question of limitation. When a person asks for a certificate, or the High Court gives a certificate in 32, 33, 34, the limitation to come to Supreme Court is not 90 days but 60 days. And that 60 days is whether the certificate is granted or not granted. So even if a person approaches the High Court and certificate is not granted, the limitation becomes 60 days and is not 90 days. Then is the articles of 138, where the criminal enlargement, the statute was passed, that is where there is a reversal of conviction, where a reversal of acquittal to conviction of 10 years. And of course 139, in 134, when the situations are that when a acquittal is reversed to that of death, or any other question which the High Court finds is important. So you would have to see, read 32, 33 and 34 a bit carefully, because the certificates are granted only in a very few circumstances other than the opinion. That's when there's a case of reversal. And 138, the power of the Supreme Court is there because of the special enactment that was passed by the Parliament, which is for the enlargement. 141 is of course the law of the Supreme Court is binding on all courts. 142 is of course the power of the Supreme Court to pass any order in matters pending before it to do substantial justice. And normally judges in the High Court only say that you don't have 142 powers, because The question then arises as to whether under 142 can you go beyond the statute or not. The Scaora judgment, which states that no, you have to visit the four corners of law, and that is why this interesting question as to whether the 6 months period under 13B, whether that can be waived or not, the matter is still pending before a larger bench of Supreme Court, because while exercising your powers under 142, whether the Supreme Court can go beyond the statute which prescribes the mandatory period of 6 months or not. That question is still there, but otherwise, Scaora judgment has categorically said that you can't break the law. You may pass any law, any judgment, but within the four corners of law, you cannot defy the mandate of law. Then comes your 139 capital A, which is the transfer jurisdiction, whether when there are two or more high courts are dealing with the same issue, and the Supreme Court feels that instead of having conflicting judgments of various high courts, it may transfer the matter to it. Or if there is a judgment pending in the Supreme Court and in the High Court, and an application is made, it can be done. The difference between 139A2 and 25 and 406 is that 139A2 is only between high courts, whereas 25 is for subordinate courts also in civil, and 406 in criminal. So the difference in 139A2 and 25 and 406, because normally the question is why should there be 25 and 406 when there is 139A2 only? 139A2 restricts it only that if between two high courts it is a civil or criminal matter. Just digressing here, for a transfer petition under section 406, the question is the Supreme Court is generally much more stringent in transferring matters for the reason that A, cases where investigation is still pending, second is where the charge sheet has been filed and the trial has started. So while investigation is still pending, Supreme Court is exceedingly reluctant to transfer because the obviously investigating agency has to be changed, and that creates a problem. And even as far as the transfer is case, unless it is established in the court that the atmosphere is so hostile that a person would not be able to give justice, and only at that point of time that the Supreme Court exercise jurisdiction for transfer from one state to other state, because you are changing the prosecuting agency itself. The state is different. All other questions which arise during the course of inquiry or trial, the High Court gets different. So therefore, the Supreme Court is very circumspect at the time of transfer in criminal cases, unlike civil cases. The maximum cases start being matrimonial cases, where the convenience of the wife is seen more. In other suits, generally the criterion would be where the witnesses decide, where the evidence can be produced. So yes, convenience of parties is also taken in civil case, but it's much easier, and especially in matrimonial matters, is normally where the wife wants the matter to be decided. Then is the 143. There now about 14 or 15 references happen where the President wants the opinion of the Supreme Court. He may refer the issue to the Supreme Court for the decision, for its opinion for the President to take a decision. And then of course the various appeals which lie to the Supreme Court, like first appeal from the NCDRC from National Commission. There, what is important is the wording of the section, because in many appeals it's only on substantial questions of law as section 100. There are a few appeals which is both on law and fact, like the Consumer Protection Act, like the Special Court Transaction Offences Related to Securities Act. There also is a case where both fact and law, and it's much more broader. The scope of the appeal depends primarily on the wording of this section as to how stringent or what is the scope of the appeal while deciding the question before the Supreme Court. That then takes us to, of course, the heart of the Supreme Court cases, which is 136. 136, as we know, is the discretion of the Supreme Court. The wording is the Supreme Court may, in its discretion, grant special appeal in any matter from any court or tribunal. Question is whether it can come against any tribunal or not. The answer is yes. Bharat Bank, the whole case, it can come against a tribunal also, but of course, the first question again is as to whether why don't you exhaust your remedy before the courts, to the higher courts. The other facet of 136 is that when you challenge an order of a high court, if the Supreme Court dismisses the special petition in limine, does it mean doctrine of merger applies or not? Kunyam of the state of Kerala, no, the doctrine of merger doesn't apply. The second question that arises is that if it does not apply, whether a review is maintainable or not in the High Court. The answer is yes till now, the review is maintainable. Then the question is that when you withdraw and then when your review gets dismissed, what you challenge in Supreme Court, you challenge the main appeal and the review or not. The answer is it depends on the liberty. What you have taken from the court, normally we were taught after Justice Kapadia, this is the Commissioner's judgment, that when you are withdrawing to file a review, please take liberty that you will have to challenge the main judgment also. Because Chennai Silks prohibits especially a petition only against Southern Silk, as to that once you withdraw, that you just can't challenge an SLP only against the review judgment. This is of course primarily because of doctrine of merger. Punya has gone to the extent that even in a civil appeal, if it's a one-line order, it is still doctrine of merger doesn't apply. Please read the judgment because I have seen questions coming on the doctrine of merger as to whether reviews can be filed. I have seen questions coming as to whether how do you withdraw, whether you can file SLP against both, against one, etc. 136 again, the dismissal of an SLP is not affirmation of an order of the High Court or merits of the case, it's only the Supreme Court decides not to interfere. There are judgments the Supreme Court says that they are not a court of correction, but a number of things goes behind the decision of the court as to whether it decides to exercise its discretion to interfere with the judgment of the High Court or not. That is more or less that takes into account the jurisdiction of the court under the various heads. Of course, the case laws in this limited time, I'm not directing further into each case. This is a broad overview. Then we come down to the Supreme Court rules. Order 4 of the Supreme Court rules deals primarily with advocates, advocate on record, who can be an advocate on record. Taking the examination, you should know what an on record is, what are the qualifications of being an on record. Order 4 also deals with senior advocate, the designation of a senior advocate. Order 5, of course, which was the initial Order 6 in the old Supreme Court rules, which is the business in chamber. Order 6 Rule 1 with business is dealt by the registrar. Order 6 Rule 2 with the judge in chamber. Have a bird's eye view. I know it's difficult to memorize the 30 or 40, but you definitely have a bird's eye view. The only difference being that against an order of a judge of a registrar in chamber, an appeal is available to a judge in chamber, whereas there is no appeal as provided from an order passed by a judge in chamber under Order 6 Rule 2. That takes us to one more question as to whether a writ is maintainable against a order passed by the Supreme Court under 136. Rupa Hurra, the classical Rupa, starts in Harishid Mirajkar, 69 Supreme Court at writs case, saying that writs are not maintainable against the orders of a court. Reaffirmed in Rupa Hurra, that's where that small window of curative came into being. That is after the dismissal of the proceedings in the court and after the dismissal of the review you can still file an application for curative. Of course, the Order 50 of the Supreme Court rules deals with I think it's Order 50, I'm not pretty sure. Order 50 of the Supreme Court rules deals with curative. The question is Order 58 deals with curative, and of course, these essentialities of curative is A review should have been filed, the review should have been dismissed, a certificate from the senior advocate stay, and the grounds which for curative being discussed in Rupa Hurra, where it is limited to the fact that notice had not been issued, the notice had not been received to a party, even in the review, and second, that the judge was interested in that cause. And of course, there are three other words, or in like circumstances, which gives us the leeway to probably give a certificate like per incurium, which the judgment does not go that extent. But yes, this per incurium is per incurium. Then if Antule says that a review or a review is maintainable for per incurium, definitely a curative is maintainable. For ex debito justitiae, fact is a judgment has been given contrary to a larger bench or contrary to the section itself, obviously to do substantial justice. The Supreme Court can never shy of its responsibilities to ensure that the law is done. Then after Order 5, we have Order 6. Order 6 primarily deals with the constitution of benches, that it says that normally the matters are heard by a bench of not less than 2 judges. Amendment came in 2019, where the certain other categories of matters can be heard by a single judge, not to be confused with Order 5 Rule 2. These are matters specifically given in Order 6, 1 proviso. Like bail for less than 7 years, transfer petitions 25 posts. That was primarily because under the 95 Act, they found that the crowds had been overcrowded, and you have 60 slots, and if more than one slot goes to a transfer petition, the court felt that it's better to amend it and bring certain cases to a single judge who can dispose of so the main board doesn't get clogged. So Order 6 Rule 1 Proviso, which was not there in the earlier, even in the 2013 Supreme Court rule as it came, brought in 2019, gives in some more classes which can be heard by a single judge. And of course, please remember 2 and 3 question can be stated as suppose a bench of 2 and a bench of 3 is a matter of administrative convenience. Can a bench of 3 without a question being referred to it overrule a bench of 2 because it happens to be a bench of 3? The answer is yes. A bench of 3 is always a bench of 3. So even though a question is not specifically referred to a bench of 3, a bench of 3 can at any point of time overrule a bench of 2. Order 6 also says as to when matters can be referred from a bench of 2 to bench of 3. And then one judgment of Justice Bharucha who says that 2 can't refer to 5 directly, 2 has to refer to 3, 3 has to refer to 5. But Article 145(3) also provides that if a question arises regarding interpretation of the Constitution, it shall be heard only by bench of 5. This is not to be taken under Order 6. That's a special provision which mandates that any question relating to interpretation of the Constitution is always heard by a bench of 5. For any other matter, Order 6 Supreme Court rules would apply regarding how matters are referred to larger benches. Then of course, proceedings against a minor, normally a minor is always represented through the guardian. If the guardian passes away, a fresh guardian has to be appointed. Till that time the matter stands state. A matter can't be withdrawn from the court unless the permission of the court is sought and leave is taken. These are the few salient things in Order 7. Order 9 deals with your affidavits, how an affidavit should be sworn, what is a matter of knowledge. There are questions which normally come from from Order 9 also regarding affidavits. And then is your Order 15, which is your petition generally, and this goes across the board. And Order 15, uh, Rule 4 states that if it is not supported with an affidavit, the appeal can be refused to be entertained. And Rule 5 gives the power to the registrar specifically not to accept such a petition. Uh, then normally a question comes between the difference between impleadment and intervention. Order 17, Rule 3, which says in person who normally doesn't talk of impleadment but of intervention. Impleadment is when a person is impleaded in the other party, thereby he becomes a respondent. Of course, we in Supreme Court we moved that provision wherein you will get impleaded as a petitioner something your court. It doesn't matter, but normally persons are impleaded only as respondents and not as a petitioner. Only a petitioner can be substituted because if it's a PIL, then if the person who is exposed passes away, and then a PIL cannot be dismissed only on the ground of abatement. Sheila Barsi's case, a person is impleaded as a petitioner to carry on the cause of action, or as we know under Order 22, when a petitioner dies, the person is substituted in his normally impleadment is of a person who is a respondent. A intervener is a person who says, I have an interest in the case and therefore I should be heard. An intervener is only entitled to receive documents and give oral submissions. He is not made as a party interested or the party in the array of parties. It will have its effect on the power to file a review also. Then as far as comes especially with the appeals as we do know 132, 133, 134, or when leave is granted, questions come on the on when to file statement of case, that is within 45 days. What should the statement of case include? Please read that. I think it's order 19 only. Order 19 only, and you have to have the statement of case within 45 days. If you do not file the statement of case, what is the consequence? Then you have to restrict yourself only to the list of dates and to the grounds taken, the documents given, etc. Which also then there's one more aspect of it before the statement of case, which is preparation of record. Once upon a time, when we were juniors and we had come here, at that time also we never prepared record. But of course, there's a full chapter given to the preparation of records where right at the end of this corridor there was a record room where you had to go there, sit down, bring the record of the court, mark those documents which you want to be in the record, then it used to be printed, and those printed paper books used to be the appeal paper book of which arguments used to be made. That was dismissed because it was taking unnecessary long time, and on records as usual were lethargic enough to go to that room, sit in the dusty room and prepare the record and mark all those documents that are necessary for the records to be printed. So now you prepare a statement of a record, you make your own documents, and then you file it in the court. That system has now been taken away. As far as the Supreme SLP is concerned, all of us know the documents required, which is primarily a certified copy of the judgment of the High Court. The certified copy is not there. An application for dispensing a certified copy, along with the petition with an affidavit and a as far as the Wakalanama is concerned, question is that the advocate in record has to certify that he is the person who signed it. If it is notarized, because many high courts, many bar councils gave permission to the lawyers to, even for the affidavit, many bar councils permitted the lawyers to administer oath, which is not there in Delhi. For example, in Tamil Nadu, in Kerala, in Andhra, in Telangana, those bar councils permit their own lawyers to administer. Because what is affidavit? I solemnly swear and affirm as under. The other states do not permit, for which purpose you get your affidavit attested by an oath commissioner, a person, oath commissioner being a person who administers oath. If your wakalatnama is notarized or is attested by an oath commissioner, means that he has seen the person signing it. If it is not there, then the advocate in the court has to generally see as to whether the person should sign before him. These amendments primarily came because there were numerous cases where wakalatnamas had been filed by persons who had passed away. There were enough cases in Supreme Court in late 80s, early 90s, where wakalats were filed by persons who had passed away, and then suddenly inside the court said, how could he file this wakalatnama swears affidavit when the man had already become sui juris. It's only to get over that this provision was brought in the 2013. Then of course there are various provisions security are covered. Then of course the review to be filed within 30 days. No necessity of a certified copy from the date of the judgment, to be heard only by the chamber. That was challenged in the Supreme Court, saying that dismissal of the review should be heard in open court. That challenge provision was rejected by the Supreme Court, some issue or something like that. And unless move an application for hearing the matter in court, which normally is never allowed, but that provision stands. The constitutional validity of that provision has been upheld. And then of course the curative, as I said, already covered. I think that in the shortest span, this is the only bird's eye view which I could give of all the provisions, and normally the questions which come in the exam, all of this. Thank you.
Thank you very much, sir, for such a comprehensive lecture. It actually covered the entire syllabus of the practice and procedure, both the Supreme Court rules and the Advocates Act. I would request Mr. Sr.Adv.Cu to give his lecture on leading cases.
Good evening, friends. Forgive my voice. Obviously, I got a bit of cold, I think, so lost my voice. I hope I can be heard at the back. Is the mic picking up my voice? Yes. Enough? Okay. So I thought I would concentrate on two lines of the leading cases. I'm told you've already been given, some of our colleagues have spoken about the basic structure and various other aspects. So the two lines which I thought I would focus on, one is with regard to judicial appointments and two very important judgments on judicial appointments, recent judgments. And the other line is on certain human rights aspects like pertaining to individual freedoms, especially pertaining to the right to marry or the injunctions against honor killings, etc. So I'll deal with those a little later. Let me first come to a very important recent judgments on judicial appointments. The first is Roger Matthew, which is a constitutional bench judgment in 2026 SCC page 1. Now Roger Matthew was dealing with a set of rules which were framed for appointments to various tribunals. We have had a constitutional provision under which tribunalization at a very sort of important and a large scale level has happened, where in a sense matters which used to be heard by the high courts in writ jurisdiction by and large have been sent to very specialized tribunals, and tribunals like the National Green Tribunal, the APTEL for electricity, the National Commission, the National Consumer Commission, and so on and so forth. There's the Competition Appellate Tribunal, and so on and so forth. There's a whole bunch of that. Now, these rules and what was done under this set of rules is that the power to appoint was essentially given to the executive and not to the judiciary, and or the role of the judiciary in making appointments was minimized, number one. Number two, the tribunals, the way the qualifications for appointment to these tribunals, even though they were replacing in effect the high courts, in those particular jurisdictions, because an appeal is then provided from these tribunals directly to the Supreme Court. So in effect, the intention was to cut out the role of the high courts there. So having cut out the role of the high courts, the nature of qualification laid down was such that there was very little discrimination there was very little distinction drawn between eminent lawyers, judges, and civil servants and so on one hand, and even within the class of lawyers, just a bare qualification of 7 years practice as opposed to persons with other contributions and an actual practice and an assessment, etc. All that was sort of given a go by. This is how it came before the Constitutional Bench, headed by Chief Justice Ranjan Gogoi, and in Roger Matthew, essentially Justice Gogoi spoke for the entire bench of 5, but there was supplementing and partly dissenting opinions by Dr. Justice Chandrachud, as his lordship then was, now our Chief Justice, and Justice Deepak Gupta. They supplemented, but they also on certain small aspects they dissented with the judgment of Justice Gogoi, of Chief Justice Gogoi. So basically, I'll just cut to the chase and come to the conclusions. But basically, what Chief Justice Gogoi ultimately held after a very detailed discussion was that so far as there were certain issues with regard to whether such provisions could have been passed by Parliament as money bills. On that aspect, the majority, this is where Justice Chandrachud and Justice Deepak Gupta dissented. Justice Gogoi, speaking with the majority here, said that these matters should be referred to a larger bench, and the money bill aspect should not be commented upon by this bench because it involves certain issues which were already pending before larger benches and so on. So that is one aspect. So far as the Section 184 of the Finance Act is concerned with regard to delegation of legislative functions, the majority held that there is no excessive delegation of legislative functions. There was a partial dissent on this aspect also by Justice Chandrachud and Justice Deepak Gupta. But the main aspect where all the judges agreed was that the tribunal, appellate tribunal and other authorities' qualification, experience and other conditions of service of members' rules 2017 suffered from very serious infirmities. They found that these rules, number one, did not give any privacy at all to the judiciary in the selection of members to man the tribunals. And they held, the bench as a whole held, that when you take away powers from the superior judiciary, from the courts of record like the high courts, you don't take away the powers as such, but what you do is you carve out and you create specialized tribunals and give them a direct appeal to the Supreme Court. You are in effect substituting the high courts with regard to those subject matters, but whereas the high court, whereas the manning of the high courts and the manning of the judiciary, even at the level of the district judiciary and lower judiciary, as well as the superior courts, the constitutional courts, the high court and Supreme Court, it has been held that manning of those courts is part of the basic structure of the Constitution, to have them independent, to maintain the independence of those courts, and therefore to choose persons who will guarantee the independence of those courts is part of the basic structure of the Constitution, and that is inviolable, and that is why the judiciary has been given primacy in selection of judges and so on. So the bench in Roger Matthew says that what is good for the high courts and the district judiciary and the Supreme Court is equally good for the tribunals. You can't make an exception and say that because these are tribunals, the government will take over the primal role in manning them and deprive the judiciary of its sort of ascendant of the position that they should have primacy in selection to ensure the independence of this wing of the judiciary which is carved out from the high courts. So in this aspect, they found that these rules were completely deficient. The rules, they did not classify enough. There was no classification between the different categories who were eligible. It was possible to man the tribunal, to select people who were not the best people for the job, because whereas Article 217, etc., which are for the Supreme Court and the High Courts, though they are very skeletal in their nature, the Constitution bench found, but the tradition which has developed and what has been developed by the three judges' judgments are that there will be a primal role played by the collegium of the Supreme Court and the collegia of the various high courts. That is completely done away with here, and the Constitution bench therefore struck down these rules in their entirety and said the rules have to be reframed in the light of this judgment. And on this aspect, Justice Gogoi's conclusions are found in para 219 onwards, and in para 223, there's a whole, it's summarized, and you can just glance straight away that para, you get a feel for this judgment. Then Dr. Justice Chandrachud, supplementing and partially dissenting judgment, his conclusions were on the finance bill aspect, the money bill aspect. His conclusions varied with those of the majority, but otherwise, with regard to the infirmities in the rules, he and Justice Deepak Gupta, in their two separate supplemental and party dissenting judgments, agreed with the majority. So this is Roger Matthew. The other important judgment which has come recently, which is a very narrow issue in a sense, is the three-judgment judgment in Dheeraj More. Now, Dheeraj More is 2027 SCC 401. Now, Dheeraj More came about because the two-judge bench held that while selecting district judges, selecting people for the district judiciary, district judges, a serving member of the lower judiciary would apply for a post, and then having taken the exam and so on, would then resign and get selected as a practicing advocate. Because to have become a member of the judiciary, of the lower judiciary, the person would have already worked as an advocate for 7, 8, 10 years, and so the qualification was there. But so the two-judge bench deferred with an earlier two-judge bench, Deepak Verma or something, I forget the name, and said that no, the judges would also be eligible and not just practicing advocate. So that got referred to a three-judge bench, and the three-judge bench, Justice Arun Mishra speaking for himself, and Justice Vineet Saran, and Justice S. Ravindra Bhatt concurring in his opinion, they took the view. They reiterated a view taken by several two-judge benches in the past, that there are two separate streams under Article 233 for appointments to the district judiciary. There are in effect two separate streams in 233.1 and 233.2. 233.1 applies to the stream which comes from the lower judiciary, that is appointment by promotion or by other methods. And 233.2 applies to a person who has been working as an advocate for 7 years or more. So what the judges have held here is that this is in effect a quota or a reservation for practicing advocates, and they say the phraseology used, has been working as an advocate, means that on the date when the person applies, when the advertisement is issued and the person applies for recruitment to the district judiciary, the person should have been working on that date as an advocate. So if you have chosen to go to the lower judiciary and you're serving in the lower judiciary, you cannot then now you can't take sort of two bites at the apple in a sense that one bite you get under 2331 to come by promotion, and another you fast track it by taking an exam and taking that what the bench characterizes as a quota or a reservation in favor of practicing advocates. You take away that also by this means. I ought to have perhaps told you right at the beginning that there are more reviews have been filed and they are pending. A large number of reviews, a batch of them, and I happen to be opposing those reviews. So either way, but that's no comment on the judgment. The judgment says what it says, and as far as you are concerned for the examination, you are concerned with what the judgment says, not the fact that somebody it may or may not get reviewed in future. So this is the board. Now I come to the human rights judgments, which are of great importance, and one of the judgments which I think, apart from Puttaswamy, which I'm sure somebody must have already spoken to you about the privacy judgment, but Navtej Johar, to my mind, is one of the most important statements on human rights. Although it is dealing with Section 377 of the IPC and the criminalization of consensual sex between people of the same gender and so on, it was dealing with that relatively narrow issue. But what this judgment did was, what the court did here, the 5-judge bench, was that they have gone into several very, very important human rights issues, and they have spelled out with much greater clarity than in the past the principle of constitutional morality, and not just constitutional morality, but Chief Justice Deepak Mishra, in his leading judgment here, it's interesting here, Chief Justice Mishra spoke for himself and Justice Khandilkar, and Justice Nariman, Justice Chandrachud, and Justice Indu Malhotra all gave their separate but concurring opinions. It was a unanimous bench, but the opinions are separately written. Justice Deepak Mishra spoke very strongly on this aspect of constitutional morality, and he held that in the interplay between constitutional morality and societal morality, it is constitutional morality which must always trump, which must always prevail. If you can't go by what society considers to be moral or immoral, you have to go by what the Constitution protects and the human dignity, the principles of human rights, universal human rights, etc., etc. And he has developed this whole theme really, I must say, exceedingly well. He then applies the litmus test to Section 377 of Article 14, Article 19, 91A, but in particular, that is the freedom of expression, and Article 21. So freedom of expression here was brought about that the individual's right to express themselves by their sexuality, by their preference or choice of partner, etc., etc. This can't be sacrificed on the anvil of what some members of society, or even the majority of society, might want, because in fact in Suresh Kaushal, which was a 2-judge bench which is set aside in this 5-judge bench, the court went on the basis that the gay community is a minuscule minority, and if it's a minuscule minority and some atrocities are taking place against them, what does it matter? How can we deal with that, etc., etc.? Why should we strike down a provision which affects a minuscule minority? That has been buried. That notion has been buried by Chief Justice Mishra, as well as the concurring opinion of Justice Nariman, Justice Chandrachud, and Justice Indu Malhotra. Justice Nariman went further because he went into the Mental Health Care Act 2017, and he demonstrated that under Section 21(1)(a) of the Mental Health Care Act 2021 or 2017, there's an express protection of sexuality and the right to make a choice, and he I can sort of take a little bit of the credit here because I appeared for 21 psychiatrists from the Indian Psychiatric Association. We had produced this act and we gave a very detailed amicus note to the court on this. But it's really interesting because he took it much further than what we had, what we were hoping for. And 21(1) of the Mental Health Care Act says every person with mental illness shall be treated equal to person with physical illness, etc., etc. And there it says, including the following: A, there shall be no discrimination on any basis, including gender, sex, sexual orientation, religion, culture, caste, social or political beliefs, class or disability. So sexual orientation in 2017, when we had a very fairly conservative sort of ruling dispensation in Parliament, but nevertheless, to their credit, this bill which had been introduced in the previous regime was carried through with all these provisions intact, and Justice Nariman built on that aspect. He also went into what we call the Yogya Karta principles, and you might like to just read those sections in Justice Nariman's concurring judgment. Then Justice Chandrachud, as his lordship then was, and Justice Indu Malhotra's judgments are both exceedingly good, but they follow the same sort of reasoning, except that Justice Chandrachud, as usual, his eloquence is always very remarkable because he has a way with words and a way of putting ideas across which makes it's very elegant and very sort of telling. Justice Indu Malhotra, and this is something which you might really bear reading, para 644, which is, I think, almost at the end of her opinion. She said, and this was something very remarkable for the Supreme Court of any country. She said, history owes an apology to the members of this community and their families for the delay in providing redressal for the ignominy and ostracism that they have suffered through the centuries. The members of this community were compelled to live a life full of fear of reprisal and persecution. This was on account of the ignorance of the majority to recognize that homosexuality is a completely natural condition, part of the range of human sexuality. The misapplication of this provision denied them the fundamental right to equality guaranteed by Article 14. It infringed the fundamental right to non-discrimination under Article 15 and the fundamental right to live a life of dignity and privacy guaranteed by Article 21. The LGBT person deserves to live a life unshackled from the shadow of being unapprehended felons. Very, very beautiful words. Then we come to C.U.Singh, another very important judgment by a two-judge bench. This was when Justice Nariman was very fresh on the court, and they struck down. This is 2015 5 SCC page 1. C.U.Singh brought a case brought by a person who was then a law student, now an eminent young member of our bar in the Supreme Court and Delhi High Court. Here basically section 66A of the Information Technology Act 2000 was under challenge. That was struck down by the Supreme Court as being overbroad, vague. It created a criminal liability where there would be a chilling effect on free speech, and Article 19(1)(a) was clearly infringed, the Supreme Court held, and what the infringement was not saved by Article 19(2), because 19(1)(a) can only be saved by 19(2), which means that it is only public order, etc., etc. The narrow exceptions made in 19(2). So the court held that it is not saved by those. The other exceedingly important judgment, which is all in your syllabus, is Shakti Vahini, 2018 7 SCC page 192. This is a three-judge bench presided over by Chief Justice Deepak Mishra with Justice Khanwilkar and Justice Chandrachud as they were. And here this judgment came about because of the rising news reports about honor killings, where people who married out of their gotra or out of their caste were being brought before panchayats, khap panchayats and so on, and the so-called person who was seen to be a deviant from the norms or mores of those communities who are being punished and sometimes even killed or banished from the community and so on and so forth. This is a very, very important judgment because Chief Justice Deepak Mishra went into the right of privacy and the right to marry and the right to choose, and held that this is completely antithetical, these sort of cup panchayats and these actions being taken against people just because of making their free choice of a partner, a life partner, or choosing to marry a person of their choice is something which is absolute anathema to the constitution, and they struck it down and they laid down very, very resounding principles here. Unfortunately, what happens is that these judgments tend to be read narrowly, as though they apply only to Shakti Vahini will be read as though it applies only to Gotras and Kap Panchayat, but it's not so. These judgments are very, very valuable to us as a part of our as sort of building blocks for our jurisprudence, because they would equally apply to an interfaith marriage, a marriage between different faiths, marriages between the same gender, and numerous different combinations, including partnerships outside of marriage, where people are just choosing to live together, etc. These the individual rights and the right to privacy, which has been expanded in this judgment, is exceedingly important, and these judgments have to be seen in that light. In light of this, though it's not in your syllabus, but Shafeen Jahan, you will make a note of it, because in the context of Shakti Vahini, Shafeen Jahan is 2018, volume 16, SCC 368. This you will all recall the case of Hadia, a girl from Kerala, a girl from South Karnataka, who married a young man from just across the border in Kerala, and who belonged to a different faith. So a Hindu girl married a Muslim boy after she had converted to Islam, and her parents virtually imprisoned her, and the Kerala High Court took the view that she did not have any agency. She did not have the right virtually to choose her own partner, that she had been misled by ISI, and it was part of an international conspiracy and so on and so forth. And in that result, in writ jurisdiction, they annulled the marriage. So the Supreme Court ultimately, after a bit of a gap, when perhaps the court itself went a bit wrong, but ultimately came good with this judgment, and Shakti Vahini are sort of two. The only reason I'm pointing this out, though it's not in your syllabus, is Shakti Vahini and Shafeen Jahan are sort of two interlinked blocks on the same theme, but except this is interfaith, and that is out of caste or out of gotra, etc., etc. So these are the judgments, I would say, are very important in the current context. You have a huge syllabus. I wish I could, talk more, but time is limited. I don't want to keep our friend Justice Subramonium Prasad held up here longer than necessary. But I'm traveling tomorrow and back on Sunday evening. Monday onwards, I'm here in the court. Anytime you have any questions, catch hold of me in the corridors, and you don't have to wait for a lecture. If you have any questions, just ask me, ask all our other colleagues. All our colleagues are always there to help you. So just feel free to do that.
Sir, may I raise a query?
Yes, please go ahead.
What is constitutional morality? Please elaborate.
Well, that's a very long question, but basically it is where the constitutional rights which are guaranteed, that is our fundamental rights are not rights which are created by the Constitution. They are rights which are inherent in humanity and in human living and human being, but they are guaranteed by our Constitution. And so where your guaranteed constitutional rights also have to do with issues which I would say which come in conflict with morality of a societal morality, that is morality which is imposed by norms of society. Many norms of society are very welcome. to behave properly, to be respectful to elders, to not to shout and scream, not to obstruct people, to drive in your lane, etc., etc. There are so many societal norms which if we didn't follow them, we would be a completely anarchical society. But there are other societal norms which can get oppressive of individual rights or of fundamental rights. And when those kind of moral norms or societal mores come in conflict with your fundamental rights and impinge on a person's individual choice, there comes this issue of constitutional morality coming into conflict or coming being incompatible with the societal morality. And I would suggest just read Justice Deepak Mishra's opinion in that judgment in Navtej Johar. You'll find it beautifully enunciated there.
Sir, may I ask a question? This morality aspect, so far as lawyers are concerned,
The morality aspect is concerned about the lawyers. It is expected from the society that they should be a high pedestal. And so far as the general public is concerned, this constitutional morality, does it confine their freedom so far as individual morality and institutional morality, and that apart this morality, constitutional morality, which have overpowered the societal morality. That is my question.
So as lawyers, as practitioners, even whether you are an Endeavour or whether you are a normal practitioner, whether you are a junior counsel, senior counsel, whatever it may be, what we need to follow, I would say morality is a very personal thing, but legal ethics are a public duty. So we have to follow legal ethics to the hilt, and that is non-negotiable. Morality, you have to have a personal morality. You have to build up your personal morality. But I think as lawyers and as AORs, we have to really examine and order our professional lives according to legal ethics, and that should never be departed from. Now this subject of constitutional morality is very large. I don't want to get into it. I think what we will do is we'll meet over a cup of coffee in the cafeteria next week sometime.
Thank you very much, sir.